أعوذ بالله من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا ونبينا محمد وآله الطاهرين وعلى أهل بيته الطيبين الطاهرين المعصومين لا سيما بقية الله في الأراضين وحجته على الخلائق أجمعين روحي وأرواح العالمين لتراب مقدمه الفداء وكن اللهم له في هذه الساعة وفي كل ساعة وليا وحافظا وقائدا وناصرا ودليلا وعينا حتى تسكنه أرضك طوعا وتمتعه فيها طويلا يرحمكم الله. So, as inshallah the brothers and sisters remember, last week we followed over 12 matters in regards to Taqleed, and we mentioned the conditions of puberty and taklif. We mentioned how can one acquire, what are the conditions of the marja', of the jurist. Inshallah, today we'll be continuing the same subject of Taqleed, and there are a few points that might take a bit long tonight. That's why we won't be covering that much, but it's necessary for those points to be explained, as the Sayyid Sistani has explained them inside his book. And I'm not adding, I'm trying to be as concise as possible so we could cover as much as we can. So, can you please read issue number 3, please?
Issue 13. If the Mujtahid whom a person follows passes away, the ruling after his death is the same as when he was alive. Therefore, if that Mujtahid is more learned than the living Mujtahid, and the obligated person generally knows that in the issues that arise for him, the two Mujtahids differ in their fatwas, even if he does not know the exact points of difference, he must remain on his Taqleed. And if the living Mujtahid is more learned than the deceased Mujtahid, he must refer to the living Mujtahid.
So, according to Sayyid Sistani, one can follow a deceased Mujtahid also. So, Sayyid Sistani allows remaining on the Taqleed of a deceased Mujtahid. The only condition is that Mujtahid that passes away needs to be more learned. We mentioned and explained the definition of learned. The person is more knowledgeable, meaning if that living Mujtahid is not more learned than the deceased one, then you can continue. But if the live one is more learned, you cannot continue on the Taqleed of the deceased Mujtahid. So, and then, now the next point is, let's say if they were equal in knowledge, what's the next criteria? Let's say we did our research as much as we could. The deceased Mujtahid and the alive Mujtahid, they are at the same level. What do we do now? Now this paragraph covers that. However, if
the superiority in knowledge between them is not known, or they are equal, then if one of them is proven to be more cautious, wara, meaning he exercises more caution in matters that play a role in issuing fatwas and delivering rulings, deriving rulings, and is more diligent in research and examination, the obligated person must follow him. If being more cautious is also not established, the obligated person has a choice to act according to the fatwa of either of the two Mujtahids, except in cases of general knowledge.
Ijmālī,
Ijmālī, or general proof, Ḥujjah Ijmālī, regarding or an obligation, in which case, based on obligatory precaution, the obligated person must observe both fatwas.
Ahsantum. Okay. Now, if they are both equal, or we don't know which one is more a'la. So the next criteria that Sayyid Sistani mentions is wara'. Wara' means someone having a sense of cautiousness, that they have more delicacy when they want to derive the ahkam. They are more, let's say more sensitive in deriving a hadith. This is just a criteria for you to refer to someone that is a person of expert. This doesn't mean you have to go examine that marja. It's really hard to do that. This is for you to research amongst the expert ones. Okay? Now let's say if you tried your best to search as much as you can and you didn't find which one is more awra, which one is more, let's say, pious here, which one is more sensitive or more cautious in their derivation of ahkam, Sayyid al-Sistani says, this is where you have ikhtiyar. You have a choice. You did your research, which one is more knowledgeable. You did your research, which one has more wara', but you didn't reach a conclusion. You don't know which one is more, which one is higher. Basically, they are equivalent in regards to our research. We didn't find which either to be superior in the other one. Sayyid Sistani says, the person, the mukallaf, has a choice in acting upon each fatwa. Let's say, if you want to act upon the Jurist A or Jurist B, that's upon your choice. There's only two scenarios, two areas and two fields that you don't have a choice. And in those two scenarios, you have to act based upon ihtiyat. Who can remember what ihtiyat was? Caution, yes. What was it? Where did we mention ihtiyat? We mentioned a mukallaf can be either a mujtahid. Mukallaf means the obligated person. Either he's a mujtahid or he is a muhtat or he is a muqallid. That's the last scenario. Usually the layman, they go after taqleed. Either he follows a marja, either he's a mujtahid himself, either he's a muhtat. Muhtat means someone that acts out of precaution, always. In this scenario, where we're going to mention these two scenarios, upon ʿilm al-Ijmālī and Ḥujjah al-Ijmālī, inshallah we'll explain it now. These two are equal. I think I have to change the marker. Sorry. These two are equal in matters of ʿilm Ijmālī. We'll explain these. And Ḥujjah Ijmālī. So, in these two scenarios, both the muqallid and the muhtat, they have to act upon ihtiyat. And ihtiyat, we mentioned, it's the hardest one, the most precautious way to act upon your obligation. That's what ihtiyat means. In the scenario of ʿilm al-Ijmālī and Ḥujjah al-Ijmālī. Now, Sayyid al-Sistani, inside his own book, he explains that ʿilm al-Ijmālī is on the board or not? Sorry. So it's the first asterisk, okay? He explains what ʿilm al-Ijmālī is. So let me just briefly give a definition of ʿilm al-Ijmālī. Who knows here what ʿilm al-Ijmālī is? Sayyidina, do you have an explanation for it? General in what sense? We don't mean general here as broad, sorry. We mean something that's not specific, unspecific. ʿilm Ijmālī means, in Arabic we say mujmal. 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 It means unspecific. I hope that's correct, but unspecific. Don't correct me on my spelling. So, can you read? Okay, ʿilm al-Ijmālī means unspecific knowledge. Usually, I'll give you a very simple example, then we'll go into the practical example. For example, let's say you know there are people inside the center. But when I ask you how many people are inside the center, you don't know. In Arabic, this is called ʿilm Ijmālī. You unspecifically have the knowledge in regards to the people present in the center. But when I ask you specifically how many, you don't know. That's ʿilm Ijmālī. It's mujmal. It's ambiguous from one aspect, but from one aspect it's clear. And it's considered knowledge. Knowledge means something that you're aware of. What are you aware of? The general sense, the unspecific sense of people being present inside the center. But when I specifically ask you who or how many people are inside, you say, I don't know. So this is what general or unspecific knowledge means. General in this sense, okay? We're going to call it general from now. It's easier to pronounce. General knowledge. Can you please read?
The entire?
Sorry,
From the start?
yes, from the start.
What is meant by general knowledge? Ijmālī. Here are cases where the obligated person knows the main obligation, asli, and knows that an act has become obligatory upon him, but he does not know exactly what that obligation is, and it remains unclear for him. In such a case, if the subject of the obligation, mukallaf bhe, is one of two distinct matters, such as qasr, shortened prayers, and full prayer, general knowledge becomes binding, munajjaz, and based on obligatory precaution, the obligated person must act according to precaution.
Ahsant. Okay. Now there are a few terminologies that we need to explain just for this matter to be clarified. Or otherwise, if someone wants to understand ʿIlm al-Ijmālī, they're going to have some problems. Okay, specifically in fiqh. So one point that we mentioned here was main obligation or taklif al-asli or asl al-taklif. So asl al-taklif I'll mention inside a example. Asl al-taklif, for example, we know in general that when the adhan of, let's say, Fajr is said, there is, or let's say adhan al-dhuhr. In adhan al-dhuhr, we say the adhan is said, you know in general that there is an obligation of prayer upon you. The prayer is asl al-taklif. The actual prayer, without any detail in regards of what type of prayer, okay? So asl al-taklif means the main obligation. Asl means main, taklif means obligation. So in this example, prayer is our asl al-taklif. Now, when it comes to salat al-dhuhr, let's say you're a traveler, you're traveling, okay? This is just an example, by the way. Okay, you're traveling. You don't know if you've passed the legal or the shari'i distance or you haven't. Let's say you don't know. In this scenario, you know at the time of Salat al-Dhuhr, there is a prayer obligated upon you, but you don't know, is that salat that you have to act upon, is that, sorry? Ahsantum. Is it qasr or is it tamam? Is it qasr or complete? So we're not mentioning that yet, okay? Okay. So is it qasr? Qasr means shortened or complete. Do I have to read 4 units or do I have to read 2 units? This is called mukallafun bih, the subject of the obligation. This is the main obligation. These two are the subjects of obligation. They are mukallafun bih. Okay? Can you read the second paragraph again?
In such a case, if the subject of obligation mukallaf bih is one of two distinct matters, such as qasr, shortened prayer, and full prayer, general knowledge becomes binding, munajjaz, and based on obligatory precaution, the obligated person must act according to precaution.
Ahsantum. Okay, now it's the time of Salat al-Dhuhr, okay? What in these two scenarios, okay? Upon what do I have knowledge?
That we have to pray.
Do I have knowledge qasr or complete? We don't have knowledge. So the only matter that we have knowledge of is the asl al-taklif, the main taklif. And when such a thing happens, when such a knowledge we have, in fiqh they call it, the asl al-taklif has become munajjaz. Munajjaz is another fiqhi terminology, which means binding. Binding. So meaning Allah subhanahu wa ta'ala on the day of judgment, He can tell you, why did you not act upon it? Okay? But when it comes to qasr or complete, God can't say, why didn't you do qasr? Why did you do complete? Why? Because the mukallafun bih is not munajjaz. What does munajjaz mean? Binding. So in the matters of precaution, what do? We don't know what the law is, we do both. So if my mukallafun bih, if my obligation, if the subject of the obligation is qasr, I have done it. If it's complete, I have done it. So I do both. This is a very brief way of explaining ihtiyat. And if Sayyid al-Sistani hadn't used these terminologies, I would have never mentioned this. I had actually no idea that the Sayyid actually opens these terminologies, because these are kind of terminologies that are only mentioned in ʿilm al-usul and ʿilm al-fiqh. So it's not that complicated, but for like general public, it could get complicated. Now, the Sayyid mentions an example. By these explanations, that would become much simpler. Can you please read the example of the Sayyid?
For example, consider a student who has chosen a city that is at the legal travel, Shari, distance from his hometown at his place of study for several years, and he is not someone who travels frequently, Kathir al-Safar. Regarding how he should perform his prayer, the first Mujtahid says, in that place the prayer is full, even if the person does not intend to stay for 10 days. The second Mujtahid, who is equal on or considered equal to the first, says the prayer is shortened, qasr, unless the person intends to stay for 10 days. In this case, on days when the student does not intend to stay for 10 days, at the time of the Zahar Adhan, he knows that the Zahar prayer is obligatory upon him, but he does not know whether it is obligatory in full form or in shortened form, qasr. Therefore, the asal of the obligation is clear to him, but the subject of the obligation is unclear. In the situation, observing precaution means that he should perform the Zahar prayer both in qasr, shortened, and full forms.
Is that clear, or do I need to explain? So he knows, he's a student, there's two maraja. If you're not a kathir al-safar also. This person is not a kathir al-safar. Inshallah, in the matter of, in the chapter of salat, who explain kathir al-safar, it has a lot of details and branches. Now, this person is at that city that he studies. It's salat al-dhuhr, and he's not staying there for more than 10 days. So the marja' number 1 says, do qasr. By the way, just a reminder again, this is in the case that the person does his research and the maraja are equal, okay? And believe me, if Sayyid al-Sistani hadn't opened this inside his book, I would have not opened this with these details. So, the maraja are equal, okay? And marja' number A says you have to do qasr. Marja' number B says you have to do complete. In the matter of ʿilm al-Ijmālī, we said, what is the ruling? What was the word? What's the ruling of a person in the case of ʿilm al-Ijmālī? We mentioned the Ihtiyat. Yes, these terminologies of ahkam, it's good to know it. It's precaution. We even mentioned it a few times there, observing precaution. Okay? So out of ihtiyat, what does he do? Does he go after marja' A or marja' B? He does both. Why? Precaution, okay. Why does he do precaution? Because he's not aware of the mukallafun bih. He's not aware of the subject of the taklif. What is he only aware of? Aslu taklif, the main. Okay. In this regard, in these matters, he has to do both. He has to observe both the opinion of marja' A and both marja' B. Can you please read the next one? However,
if the case is not one of general knowledge, such as when the mukallaf does not know the asal of the obligation and the obligation itself is doubtful and has not been established by a valid, credible proof, then observing such a precaution is not required in this case.
Ahsantum. Okay, now we said ʿilm al-Ijmālī. What did ʿilm al-Ijmālī mean? What does it? General knowledge. Okay, in this regard, we had general knowledge. And knowledge, when we say, we mean certainty. We were certain that there is a prayer obligated upon us. But let's say in a scenario that we're not certain. do I still have to do ihtiyat? No. Why? There's no binding law. Because there's no knowledge. For example, imagine Allah subhanahu wa ta'ala as, let's say, a boss, okay? Or let's say our own. We are slaves of God, Abdullah. As a master, okay? The master has given a law, but I'm not aware of it. Can that master punish me if I don't abide by it? No, because I have no knowledge of it. When I don't have knowledge, the law is not binding. It's not munajjaz. The law is only binding when I am a knowledge of ahsantum. I have knowledge of it, ahsantum. Okay? So when it's not a case of general knowledge, ʿilm al-Ijmālī, I don't have to follow. Okay. Or, sorry, I don't have to do ihtiyat. I do have to follow, but it depends on what the case is. Can you now read the example?
For example, consider a car that is appropriate to a person's status and is used for personal and family needs and is counted as living expenses, which the person bought from his income during the year. After several years of use, he sells the car without any increase in price. In this case, the first Mujtahid says the money from selling the car does not have khums. The second Mujtahid says the money from selling the car has khums. Therefore, in this situation, the obligated person is in doubt regarding the asl of the obligation and does not know whether paying khums is obligatory upon him or not. In this case, if the two Mujtahids mentioned are equal or considered equal knowledge and precision, as explained, the person may follow the Mujtahid who says that money does not have khums, as it is not necessary for him to act according to precaution and pay its khums.
Ahsantum. Thank you very much. Now, in this example, inshallah everyone was ready. What is asl taklif? Khums. What is khums? Does everyone knows what's khums? Yep. 20% of the extra. The extra, okay? You have to pay the 20% or the 1/5 of the extra. Okay, now in this example, the asl taklif, what was asl taklif? Who can translate? The main obligation. The main obligation is khums. Now, in this regard, what was the opinion of marja A? Pay. What was marja B? Don't pay. Don't. So, khums, when it comes to defining it, what is khums? It's paying, literally paying. So, the doubt that we have, what is it attributed to? It's attributed to the main obligation, to asl taklif. So there is no ʿilm al-Ijmālī. I don't have general knowledge. There is no knowledge there. There is no law that is binding towards me because I am unaware of asl taklif. What is asl taklif? Khums. Marja A says, do it. Marja B says, don't do it. It's not like the prayer one. Marja A says, do it, but in qas. Marja B says, do it, but incomplete. Both agreed in the past example that you both have to do it. But here, the difference of opinion is in doing it or not doing it. So the main obligation is doubtful. Sorry, why am I writing crooked? Is doubtful. So it's not ma'loom. They say mashkuk. So aslu taklif mashkuk. Aslu taklif ghayru ma'loom. It's not clear. We don't have any knowledge in regards to it. Okay. Okay. I actually don't know why the Sayyid has brought this up here. But it's good for general knowledge in regards to someone learning their fiqh. Alhamdulillah. Astaghfirullah. Okay, can you read the next?
Also, if the case is one of general knowledge, but that general knowledge is not binding, munajjaz, then observing precaution is not required, such as when the obligation is between two matters that are less and more.
Now, before we mention the two examples that the Sayyid mentions, there is another type of general knowledge that is not binding. Does anyone know what it is? What type of general knowledge? ʿilm al-Ijmālī, we explained what it is. Unspecific knowledge. Let's say to your own judgment, let's say without being aware of these terminologies, what do you guess that general knowledge that is not binding could be? Anyone? No one? Okay. So, there is a type of general knowledge, let's say ʿilm, what am I writing? ʿilm Ijmālī, general knowledge. I'm writing this in Arabic so you guys get more familiar with the terminologies of fiqh. Well, otherwise I would have written it in English only. So ʿilm Ijmālī. So it has two types. One that it is these are actual fiqhi terminologies that if you study fiqh, they will mention. So ilm al-ijmali could be between two mutabayinain or aqallu akthar and ihtimali. Mutabayinain was the past example. Two distinct actions. What were the two distinct actions in the past example? Who can tell me? No. That is also mutabayinain. But in the ilm al-ijmali one was qasr and complete. Yeah, qasr and complete. Mutabayinain means distinct, two things that are distinct. So the prayer of qasr is different than the complete prayer. They are two separate actions. So this is ilm al-ijmali, mutabayinain, distinct, that one is qasr and one is complete. That's the example for it. Now, the second type, they call it aqal wa akthar and ihtimali. Over there, less and more. Aqal wa akthar. That's ihtimali, that's a usuli terminology. So it's probable between two types. More or less. Aqal means less and akthar. Who knows an example for this? Anyone? I'll mention it now myself. Let's say aqal wa akthar is this. Tasbihat أربعة let's say times 1 or تسبيحات Okay, this is an actual example inside fiqh. So who knows what tasbihat al-arba'a is? Subhanallah walhamdulillah wa la ilaha illallah Allahu akbar. Everyone knows what this means. I'm going on to every word so I don't write ambiguous words on the board. So the example that we mentioned in aqallu akthar, and these are two actions that are not distinct. Tasbihat al-arba'a, if it is said 3 times or said once, they are both the same action, but one is once, one is 3 times. It's not distinct. In the cases that we have general knowledge and the two cases are not distinct, they are the matter of more and less, like these two, what does it say? Observing precaution is not required. Why can someone say this? We mentioned it. It's not binding. How? It's not that easy. You gotta think it. Why is this binding, but this is not binding? And there's a clue on the board. Sorry? One tasbih is what? It is sufficient, yes. But why is ʿilm al-ijmālī? Why does ʿilm al-ijmālī not necessitate precaution?
Because it's less and more. For the second case, it's less and more.
We don't have knowledge of a certain case between the two. It's this ijmal, this ambiguity, this unspecificness comes all the way here. Here, no, it stopped here. We had knowledge to the asl taklif, but here it's different. Okay? So I won't get into more branches. It might get a bit more complicated or confusing. I hope no one's confused.
Quick question. So what
Please.
was, for example, the khums of
Khums, which one is that?
the example of the khums? You said that it's the asl taklif.
Khums is this? It's doing and not doing. Doing an action and not doing an action, are they distinct or not?
But then for the qasr and complete, we know the asl taklif, which is a prayer, but then the
We don't know what type.
type of prayer.
But in khums, we don't know. Is it khums or not khums?
So it still falls on the bayani.
Yes. Yes. It's between, they call it between, you asked the question. It's between wujud and adam. Existence and non-existence. Wujud al-hukm wa adam al-hukm. Sorry, it's a bit philosophical. That's usul, bro. So if I said, if Sayyid al-Sistani hadn't mentioned it inside the book, I wouldn't have raised this. Sorry? Yeah, like binary coding. Ahsantu. Okay, now, who can revise where we were at? We're ʿilm al-Ijmālī in the matters that's not distinct, متباينين. It's أقل وأكثر. More or less, the Sayyid said, observing precaution is not required. In this case, two examples the Sayyid gives. Can you read example A, please?
If one mujtahid says it is obligatory for the one praying to recite the tasbihat al-arba 3 times in the third and the fourth units of prayer, and another mujtahid says one time is sufficient, then if the two mujtahids are equal or considered equal, the mukallaf may allow the mujtahid who considers one time sufficient.
Follow, not
May
allow.
follow the mujtahid who considers one time sufficient.
Ahsantu. So in this case, let's say Mujtahid A says Tasbihat al-Arba'a, 1 is enough. The Mujtahid B says, by the way, again another reminder, these two Mujtahideen are equal. Okay. So if Mujtahid A says 1 time, Mujtahid B says 3 times, what does the Mukallaf do? He can do. It's very important. He can do 1 and he can do 3. He doesn't have to do Ihtiyat. What was Ihtiyat? The harder one, yes, or 3, ahsant. Okay, so can you read example B? Alhamdulillah, these examples quite explain all these examples. Okay, can you please mention B?
So can we say that, in all of these cases, it's about making it easier for us to, in this case, it's it's making it easier for us to pray. At the end, it's making it easier for us to pray.
When Allah subhanahu wa ta'ala, this is the mercy of Allah subhanahu wa ta'ala, when the mukallaf, the person that's obligated, when the mukallaf is unaware of his obligation, Allah subhanahu wa ta'ala takes it complete ease. But when he is aware, he has to do his obligation. No, in Islam, not the main headline is not convenience. Sometimes praying gets hard, and inshallah we'll get to those parts. So this world is not an easy place. So. B. Yes, ihtiyat. Yeah, the other one, when you have to read qasr and complete. Yes. Qasr and complete, you have to pray twice. It's not always easy. So if one mujtahid says, this is example number 2 for ʿilm Ijmālī, when it's more or less, ahsant, and we don't have to do ihtiyat. B, if one mujtahid says,
If one mujtahid says in wudu, wiping the foot from the tip of one of the toes up to the top of the foot is sufficient before the joint, and another mujtahid says wiping the foot from the tip of one of the toes up to the top of the foot is not sufficient, and in addition the top of the foot up to the joint may also be wiped, then if the two mujtahids are equal or considered equal, the obligated person may follow the mujtahid who considers wiping up to the top of the foot sufficient. However, if one of the two mujtahids is more learned than the other, the obligated person must act according to the fatwa of the more learned.
obviously this is just a branch that the Sayyid gives out of the equation. So that's if one of them is a'lam. But in this scenario, they were Equal. Okay, Hassan. So imagine this is a foot. Sorry, I don't have much talent in drawing. One mujtahid says it's enough to do wipe until here, from the tip until the joint. Mujtahid B says no, you have to wipe until the top, cover the whole thing, the whole joint. What type of these two are these? Is this example? It's less or more. This one says less, this one says more. In this case, you don't have to act upon ihtiyat. You can wipe from here to here, or you can wipe from here to here. These are examples, and this is not the hukm of Sayyid Sistani. I'm not saying. This is just an example, okay? If it's quick.
Just to ensure that I'm not confused.
Okay.
We're still talking about doing taqleed of a second mujtahid if your mujtahid.
No. Let's say deceased mujtahid mujtahid has passed away. Now, yes, we are. And these two mujtahid, the mujtahid that's alive, we did not reach a conclusion in which one is more knowledgeable or which one has more wara', more sensitivity in deriving. Yes, they are both equal. Or we didn't reach a conclusion. We don't know. It's like as if they're equal. This is what we do, and this is the main thing. Ilm al-Ijmālī, general knowledge, unspecific knowledge. Okay. Did we read?
For example, two mujtahids may give a fatwa regarding a person who has gone.
Sorry. No, that's another. So read it should be noted.
It should be noted that for more detailed knowledge about the exact cases where precaution is required or not required, one should refer to the specialized books of jurisprudence or ask people of knowledge.
Ahsantum. Okay. This explanation that we gave was literally 1 day of 6 months of usul. So this subject of Ilm al-Ijmālī took us 6 months to cover. It's one of the most branched and most detailed parts of usul and fiqh, and the ulama still have an entire argument about it. Okay, the Sayyid mentioned that this wasn't sufficient. If you want more, you got to go to specialized books. Okay, now asterisk number 2. Who can remember what asterisk number 2 was about? Can you read if being more cautious?
If being more cautious is also not to
Established.
establish, the obligated person has a choice to act according to the fatwa of either of the two mujtahids, except in cases of general knowledge, Ilm Ijmālī, or general proof, Ḥujjah Ijmālī, regarding an obligation, in which case both based on obligatory precaution, the obligated person must observe both fatwas.
Okay, in this case, the Sayyid was explaining Ilm al-Ijmālī, we explained Ilm al-Ijmālī, took us that long. And now Ḥujjah Ijmālī is another case which is similar to Ilm al-Ijmālī, but it's a bit different, okay? Inshallah this would be easier and it's a bit shorter too. Inshallah we'll get over it. Now this is asterisk 2, this is the Sayyid's explanation on Ḥujjah Ijmāliyah, general proof. How did we define general? We said unspecific. Unspecific Ḥujjah. What was the definition of Ḥujjah? We mentioned it. What does Ḥujjah mean? No one? Proof. Ḥujjah comes from the word Ihtijāj. Means something that a master can argue over. يحتج به. Something that a master can argue over, and it could be his proof over the slave or the obedient person why he did not act upon the obligation. Ḥujjatun Ijmāliyah, because it's mu'annath, it's correct. Okay. Ḥujjah. Okay. A Ḥujjah that is ambiguous, that is unspecific. It's still a proof, but it's ambiguous. So another point that's a bit common with the past is that we mentioned the hukm of Allah subhanahu wa ta'ala, or let's say the knowledge that we have when we are aware of our obligation. Allah subhanahu wa ta'ala can argue and say, why didn't you act upon your knowledge? That knowledge could be a proof. Now, the proof exists, but my knowledge doesn't exist. I'm not aware of it. Can anyone give me an example when could a proof exist but I'm unaware of it? No one? Okay. No, you're not mukallaf. Taklif is repelled. Okay, now the Sayyid gives an example, don't worry. I just wanted to make it a bit easier. What is meant by, can you please read asterisk number 2?
What is meant by general proof, Ḥujjah Ijmāliyah, are cases where the obligated person himself does not have knowledge of the asal of the obligation, but the asal of the obligation has been established upon him through a legal proof, Ḥujjah Sharia. However, he does not know exactly what that obligation is, and it remains unclear for him personally. In such a case, if the subject of obligation mukallaf bih is one of two distinct matters, such as fasting or giving charity, the general proof Ḥujjah Ijmāliyah becomes binding, munajjaz, and based on obligatory precaution, the obligated person must act according to precaution.
The Sayyid said, the person has no knowledge. He has no knowledge in regards to asl taklif, which is the main obligation. But the proof is there. Now the Sayyid would explain how could it be that the proof is there, but the person has no knowledge. We'll mention it in the example. Mukallafun bih was what? The subject of the obligation. When you have no knowledge of asl taklif, could you have knowledge of the subject of the obligation? No. So you don't have knowledge of asl taklif. You don't have knowledge of mukallafun bih, the subject of the obligation also. The only thing that is present is a proof. And that proof is Ijmāliyah. The case is, according to Sayyid Sistani, when a Ḥujjah is present, as long as the Ḥujjah is present, that Ḥujjah is munajjaz. It's binding. Why? Because Allah subhanahu wa ta'ala on the Day of Judgment, He can do ihtijaj with it. You can be held accountable by that Ḥujjah. Now the example that the Sayyid mentions is, inshallah, explanatory.
For example, two mujtahids may give a fatwa regarding a person who has gone for a Hajj and has committed a prohibited act from prohibition of ihram during the rites of Hajj and in the form of fiqh, legal matters. They say a person who commits such a prohibited act from the prohibitions of ihram must give a kafara. However, the two mujtahids differ in determining the type of kafara, and in another independent fatwa separate from the first issue, they specify the type of kafara. For example, one of the two mujtahid says, the mukallaf who commits the prohibited act from the prohibition of ihram must fast for 3 days. And the other mujtahid says, the mukallaf who commits the prohibited act from the prohibition of ihram must give sadaqah, charity. And the mentioned kafara, according to both fatwas, is specific for ta'yini, and not optional.
Takhiri. Sorry, these are fiqhi terminologies. Okay, now in this explanation, in this example, there is a Ḥujjah Ijmāliyah. Where is the Ḥujjah Ijmāliyah? Can anyone tell me? Someone has gone to Hajj and he is in ihram. And when you do ihram, I don't know if just a very brief thing, that ihram is something similar to takbiratul ihram. When you pray, when you say Allahu Akbar, can you drink water? Can you eat? You can't do certain actions. Inside prayer, 4, 5, 6 minutes. But when you go to Hajj, Hajj has manasik, has certain rights. When you do the ihram and do the niyyah of ihram, certain things become haram for you. You can't do many things, okay? And if you do one of those things, if you commit one of those sins, that sin could also have a kafara. You have to pay something. There's a repercussion of that action. In this regard, one of the mujtahideen says that you have to fast for 3 days. Another mujtahid says you have to give sadaqah. Now here, this person himself, he has no awareness of what the taklif is. Does he have any awareness of the subject of the taklif? No. What is the only present matter here that could be binding to him? No, the fatwa. the fatwa. In another independent fatwa, this is the key word here. There's two fatwas. When he sees the two fatwas of these mujtahideen, he says, I don't understand this, but I know there are two mujtahideen that every single one of them is giving an independent fatwa. This is not ihtiyat wajib. This is not obligatory precaution. No, this is a fatwa. Both maraja have a fatwa. He has no knowledge. He doesn't know what his taklif is, but there is a hujjah here. There is a proof. Two maraja are giving a ruling, not just a normal ruling. They're giving an initial fatwa, separate fatwa. That's a really determining factor here. There has to be two separate fatwas. Because of the existence of that fatwa, ahsantum, this guy has to do ihtiyat. He has to do both. He has to fast for 3 days and pay sadaqah. Because there is an unspecific hujjah present here. And we mentioned what the hujjah was. Should we know that? Inshallah, that's clear. And about the ta'yini. And say it says, and this is why we said it becomes binding. Both maraja don't say that person has a choice. It's not takhyir. He says it's ta'yin. It means, sorry? Compulsory. Who can give me another example of takhyir and ta'yin? No one? Okay, I'll say it myself. It's okay. For example, praying. Praying, the obligation of praying is mu'ayyan. You have to pray. But when it comes to the time of prayer, when do you have to pray? You can pray the first 10 minutes, second 10 minutes, or the last 10 minutes. It's on your own choice. It's upon your own choice. That's takhyir. In regards to this matter, the both fatwas, they have to be a determining separate fatwa. It cannot be precaution. It has to be a fatwa, and the fatwa has to be ta'yini. It has to be specific. He can't say either you do fasting or either you do charity. That marja has to give a fatwa of you have to pay charity. You have to fast for 3 days, for example. One of the two, okay? Inshallah, that's clear. In this case,
if the matter of kafara is not from the certain and established rulings of jurisprudence, the obligated person does not have knowledge that an obligation has come upon him, but based on the statements of two mujtahids who are equal or considered equal in knowledge and precision, the asl of the obligation of kafara becomes established upon him, yet he does not know whether it is fasting for 3 days or giving sadaqah, charity to the poor. Therefore, the subject of the obligation is unclear for him. In this situation, observing this requirement of precaution means that the person should both fast for 3 days and give charity, sadaqah.
We explained this. Thank you very much. We mentioned the person is unaware of the mukallafun bih, the subject of the obligation, as the Sayyid says. What comes upon him is the two fatwas. And the two fatwas are munajjaz, they are binding. Because it's unclear upon him, but the proof is present, he has to act based on precaution. Can you please read? It should be noted.
It should be noted that the other explanations of general proof, Ḥujjah, Ijmāliyah, are similar to those of general knowledge, and due to concession, they are not mentioned here. For more detailed knowledge about the exact cases where precaution is required or not required, one should refer to specialized books of jurisprudence or ask people of knowledge.
Ahsantum, thank you very much. Okay, so the Sayyid says if you want more details, this was just a very, very extreme brief of what Ḥujjah Ijmāliyah means and what ʿIlm al-Ijmālī means. So that's ʿIlm al-Ijmālī. Now, let's go to the next number. Number 14.
Number 14, if a person remains on the taqleed of a deceased mujtahid without the permission of a living mujtahid, he is like someone who acts without taqleed. Such a person must, in the matter of remaining on the taqleed of a deceased marja, refer to a qualified living mujtahid and follow him.
Ahsantum. So as this is a follow-up to number 13, where the Sayyid said, someone you cannot continue practicing following a jurist if he is not alive or he is not qualified. Qualified in this regard means he's not alive, for example, or he's not more knowledgeable than the alive one. You can't just continue without permission. You have to continue based on permission. That's what the Sayyid wants to explain here. If a discerning child, remember, who can remember what Mumayyiz was? Mumayyiz?
Child who is not at the age of
Puberty. Ahsantum.
knowledge and their awarenesses.
He has a certain awareness to certain laws of Allah subhanahu wa ta'ala. And specifically to those certain laws, he becomes an mukallaf, an obligated person. But the only thing is that Allah subhanahu wa ta'ala won't punish him. So if he doesn't do it, for example. So if a discerning child means a mumayyiz. And we explained what mumayyiz was in the past week.
Number
Can-
15, if a discerning child's mumayyiz performs taqleed, his taqleed is valid. Therefore, if a mujtahid whom a person followed before reaching puberty passes away, his ruling is the same as that of adults as mentioned in number 13, except regarding the obligation of precaution, Ihtiyat wajib, between two opinions in cases of general knowledge or general proof, where precaution is not obligatory for him before reaching puberty.
Ahsantum, thank you. So when someone becomes mumayyiz, he can legally, according to Islam, do taqleed. And that taqleed could be counted as his official taqleed. Let's say someone is mumayyiz and he starts taqleed of a marja'. And that marja', before this kid reaches puberty, passes away. Can this kid, with the permission of a live marja', can he continue the taqleed of that deceased marja' if the conditions apply? Yes, he can. It's just like a person that has reached puberty. Unless in the cases of ihtiyat wajib, that for the mumayyiz child, ihtiyat is not wajib at all. Ihtiyat is only for a person that has reached puberty. Who can tell me why this is an extra note that just gives us a reminding of what we mentioned here? Because when someone has not reached the age of taklif, age of obligation, Allah subhanahu wa ta'ala has no binding law against him. Allah subhanahu wa ta'ala would never punish him for something that he misses out. That's only for someone that has reached taklif. That's why ihtiyat is not wajib for him. Ihtiyat is only when you're sure something is binding upon you and you want to fulfill it. Okay? Can you please read number 16?
It is number 16. It is necessary for the obligated person to learn the issues he commonly faces, which he thinks that by not learning them he may leave a wajib or commit a haram.
Ahsantum. Just this is another recap of the hadith that we read before. That if I don't go learn my religion, I could fall into this, a sin or neglect a wajib. It is wajib upon everyone to go learn the matters that they could deal with on a daily life. Can you read number 17?
Number 17, if an issue arises for a person and he does not know its ruling, he must act with precaution or perform taqleed according to the conditions mentioned. However, if he does not have access to the fatwa of the most learned alam, in that issue, it is permissible while observing the order of most learned to learn less learned, al-alam for al-alam,
Al-a'lamu fal-a'lam. Yes.
to follow someone that's not the most learned.
Ahsantum. So let's say you did your research but you didn't find the ruling of the marja', okay? Or you weren't aware of it. The Sayyid says you can act based on precaution. Or according to the conditions mentioned, perform taqleed according to the conditions. Basically do taqleed or do ihtiyat. This is the hukm that we mentioned a few times. Now let's say someone doesn't have access to the ruling of the actual a'lam. Or let's say the marja' doesn't give a hukm. It's not wajib, know this. It's not wajib for a marja' to give a hukm. A jurist could say, I don't know. Sayyid Sistani could say, I don't know. I don't feel safe, for example. There are some matters when you ask the Sayyid says, I don't want to express my opinion. In those cases, you can go to the next most learned person. We mentioned the order of the most learned. Al-a'lamu fal-a'lam. Can you please not play with the chair? Okay. Can you please read number 18?
if a person tells the fatwa of a mujtahid to another person and then that mujtahid fatwa changes, it is not necessary to inform him that the fatwa has changed. However, if after conveying the fatwa he realizes that he made a mistake and that his statement would cause that person to act contrary to his religious duty, he must, based on necessary precaution, correct that the mistake if possible.
Ahsantum. Let's say someone asks you a question, what is the hukm of Sayyid Sistani? And after a month, the fatwa of Sayyid Sistani changes. It's not wajib for you to go and update him. You can, but it's not wajib. The Sayyid is saying it's not necessary. But let's say he came and asked you an opinion and you said the wrong answer. And that wrong answer could cause him to act opposite or contrary to his actual duty. Yes, based on obligatory precaution, Ihtiyat wajib, you have to go and update him, tell him I made a mistake. Who can tell me here? Now let's say, imagine we're being technical here. You mentioned the wrong ruling to someone and then that could cause him to do wrong. Do you have to go and update him?
If we found out that it was the wrong ruling, then yes, we have to go and correct it.
Okay, so we said we're being technical. No. According to Ihtiyat wajib, you have to. Let's say the next marja, let's say Ayatollah Wahid, for example, he says you don't have to. You don't have to go update him. This is obligatory precaution. We said in obligatory precaution, when it's not a fatwa, you don't have to do it. Yes, if you want to remain on Sayyid Sistani, you can. You have to go update him. But let's say you go refer to the next most learned. Let's say, for example, Shaykh Wahid al-Khurasani is the next one. And he says you don't have to update him. Even if he acts contrary to his own obligation, you don't have to update him anymore. Why? Because Sayyid Sistani didn't give a fatwa here. What did he say? Based on necessary precaution. Ihtiyat lazim. Okay? So the next one, inshallah, we can't finish it in 5 minutes. The next one is a long one. Inshallah, we'll do it next week. I don't want to hold you guys up here and tire you. And this was about 4 or 5 matters of fiqh in regard to taqleed. Inshallah, next week we'll be continuing it. The matter of taqleed can get really detailed and it's very necessary. Just like the aqa'id that we have, taqleed is like the foundation of fiqh itself. If I don't know based on what I'm following the jurist or according to what rulings or what's the ruling of me following this marja, I would be basically following him without knowing certain details, kind of blindly. Okay, so this chapter also acts as a foundation of fiqh itself, and inshallah in the next week we'll be continuing it. وصلى الله على سيدنا ونبينا محمد وآله الطاهرين.